This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
First selection process and the rule framed by the board. The point is that, as per my judgment also, the candidates, the tainted candidates are not eligible. But as per the rules framed by the board, they are eligible. And this is one point. The marks obtained in the years 2016 election process was 45%. Not eligibility.
But problem is, Mr. Mitro, this notification dated 30th May 2025 for initiation of fresh selection process is strictly in terms of the order dated 17th April 2025 passed by the Supreme Court. Now, therefore, and with the time schedule, Supreme Court gave direction. Now, today interfering this particular notification dated 30th May 2025 amounts to tinkering with the time schedule which has been fixed by the Supreme Court.
Our point is without.
So therefore, I would request the petitioners to approach the Honorable Supreme Court for getting appropriate clarification, because issue is not alive before this court in view of the order.
We are not asking for any modification or even clarification.
Yes.
Supreme Court order. What point is the rule to this 3 points I have raised, and the 3 points are inroad into judicial power. If the court has passed an order, the legislature or this board has no jurisdiction to circumvent that order by any process, by making rules otherwise. Our is the
problem is interference or passing an order, tweaking the conditions as contained in this notification amounts to extension of time. That is impermissible in view of the order passed by the Supreme Court.
I'm going to ask you for no extension of time. We are saying that this board cannot frame any provision in the rule. We point out 3 provisions in the rule where they have made inroad into judicial power, judicial order. That is why they cannot be, they are invalid, totally invalid. That is the point we have taken, my lord. Relying on the judgment, we are not asking for any clarification, etc. No clarification, no. We rely on Supreme Court judgment. Relying on my lord's interpretation of Supreme Court judgment, that tainted candidates are not permitted to appear in the fresh selection process. But their qualification they have framed, I mentioned in the note, the qualification of appearing is not that being tainted is no disqualification. The dividing line drawn by Supreme Court between tainted and non-tainted, untainted, has been obliterated. That is the point we have taken, my lord, in this point. Next point we have taken the qualification mark, which was 45% in B.Ed and BA graduation.
Now it has been enhanced to 50%.
50%. So but the Supreme Court order is those, and High Court order, Supreme Court order is that those who are untainted and are qualified under the 2016 rules have the right to appear in the fresh selection process. They cannot be disqualified in this fashion indirectly.
But this clarification should be obtained for prima facie, my view, should be obtained from the Supreme Court. Because there was a direction, Mr. Mitro, by the Supreme Court that to file an affidavit bringing on record this notification. So therefore, the Supreme Court is in session of the matter till date. So if any clarification is required, that should be obtained from the Supreme Court.
I appreciate my observation.
First of all, what is troubling this court, try to appreciate the predicament of this court, that first of all, there's a time schedule. Second, Supreme Court directed that you file an affidavit disclosing the steps taken in terms of the order passed by the Supreme Court on 17th April 2025. If that be the position, what is the scope left open to this court to interfere with the notification dated 30th May 2025.
How many
If the issue would have been wide open, then court could have exercised its judicial power.
Yes.
But otherwise, in view of the situation which is emanating, in view of the order passed by the Supreme Court first on 17th April 2025,
Yes.
coupled with the order passed by the Honorable Division Bench in the contempt proceedings, it prima facie it appears that the issue is not open before this court.
So this is the हमने सबमिट I learned that. That's हमने cancel मिला. Me particularly, that I do not want to ask for. I cannot ask for any order which may cause slightest embarrassment to our High Court.
Yes.
If I go to Supreme Court now, well, Supreme Court said this has happened subsequent to my order. So these things are good or bad. Let the High Court decide. The time all the Supreme Court can do is extend the time limit so that these things can be done or not. Lordship may be pleased to say that parties are, after considering my application, parties should free to apply for clarification Supreme Court regarding extension of time. This, if the errors they have committed cannot be rectified within a time schedule, and fresh election process cannot be completed in terms of law, in terms of the order passed by the court within the time schedule, then parties may.
It's a huge process because starting from 1st of June, if it is to be concluded from 31st December 2020 or 31st December 2025, it's a huge process.
Yes.
Now interfering this notification dated 30th May 2025 amounts to a situation where authority has needs to get an extension of time
Yes.
for completing the selection process. Now, as you are submitting, Mr. Mitro, that leave can be granted by this court after passing necessary directions with regard to the nature of notification issued by the commission, to that the leave can be granted to approach the Supreme Court for extension of time. So if the approach has to be made before the Supreme Court for extension of time, considering the enormous work which has to be carried out by the authorities to complete the selection process, let there be a further clarification with regard to the conditions of that notification.
Absolutely, Somnath. When only one this humble submission. If only the court holds that the rule, some three provisions, three clauses in the rules are violative of court's order, only then, my lord, we can say, court can also say that for rectifying the mistake committed by the board may apply to Supreme Court for extension order if they cannot complete the process after rectifying this their own mistakes within time schedule.
If certain observations are made.
Yes, unless court holds, it is the ground. There's at this primary
Mr.
case.
Bhattacharya, why untainted tainted candidates are being permitted in spite of the direction by the Supreme Court? Because in your notification dated 30th May 2025, there is no explicit bar I have seen to debar the tainted candidates from making application.
Kindly comes to the notification.
Yes, I can refer. I can make an observation that yes, these are the demerits or these are the loopholes of this notification dated 30th May 2025, but court is not interfering with the issue since the leave is granted. But you satisfy that why the candidates, tainted candidates will be permitted to participate in view of a specific observation made by the Supreme Court.
First submission is we'll come back with the
Yes.
has fallen from your lordship. We'll come back on
Yes. I know other matters are fixed.
Yes,
And Mr. Mitro will be there on next one.
Any preempting of any decision. Second thing is, whatever we have done, do not record anything. We have done strictly in adherence to the Honorable Supreme Court.
Yes, that you have
Nothing
submitted
beyond.
yesterday.
Nothing beyond.
Yes.
I am
Nothing beyond.
activating an ill motive.
we have taken the query.
Commit an error is human. They may have committed an error and they will manly accept it and correct it now. I am not.
We have
Yes.
taken down the queries which are falling
No,
from
no,
the
but
honorable
this
court.
is also this is also troubling me. The Supreme Court has said that tainted candidates will not be permitted. Where is such indication in your notification?
Yes.
We'll answer it.
We'll answer it on that.
I do not.
There cannot be any piecemeal answer to this. The entire
You
all
don't
the
take
orders
the
have to
risk
be
of
read
answering. at this stage when Mr. Mitra is appealing on behalf of the petition?
Of course.
Huh?
He can, do anything with any,
Yes,
no matter
court will-
can become some matter.
Court will accept your submission. What Mr. Mitra is submitting, that court will accept your submission. Yes, let the issue be pointed out before the Supreme Court by making an appropriate application. But these are the things which prima
Yes.
appears to be
We-
not
we-
not in consonance with the observations made
We
by the
have to
Supreme
try
Court
We have
in the
to
order
get
dated 3rd of April 2025 and 17th April
We have to
2025.
tell the court, Supreme Court, that a ground for extension of time. What is the ground for extension of time today?
all humility, I propose to recuse myself at this stage by not making any submission.
Think over it. Hold.
He's on the other side. He's on the other side. He can make something out of nothing.
Think on this issue.
Mr. Anil
Hold
Kapoor-
periodical conferences and come back.
Not in the court, not in the
Sir, sir.
And come back. That why tainted candidates are not debarred explicitly.
Not disqualified.
Very. Whatever has fallen from the law.
We have taken note of it, we'll come back with an answer.
Very.
And two more points I'm indicating that mark now we made 50%. That cannot be made applicable to the untainted candidate who has successfully appeared and succeeded on the basis of their qualification mark was 45% in that state. Qualifications are fixed by 2016.
The Supreme Court directed strictly considering the recruitment rules which was prevalent.
Yes,
Now, if that is so, why further changes were brought in
that's
30th September, 30th May 2025 notification in order to avoid complications?
That also.
this is
The learned advocate general is also appearing for.
Yes.
very good.
I do not know whether he has been served, in terms of the appellate side route because the.
That's a different matter, but he'll assist in any event.
Ask Mr. Dotto to appear on Monday.
Yes.
Tell Mr. Dotto.
I'm seeking their cooperation, not any hostility.
Yes.
This is the things to be learned. These are the things to be learned.
Issue.
Lawyer.
Matter is heard in
একটু
presence
appearance
of Mr. Onindo Mitro, learned senior advocate, and Mr. Vishwarup Bhattacharya, learned counsel representing West Bengal Central School Service Commission, and Mr. Shishanno Bandyopadhyay, standing counsel representing state respondents. Since other matters touching upon similar issue are fixed for consideration on Monday next, 7 July 2025. Let this matter appear along with those matters on 7 July 2025 for further consideration.
Grateful.